Good afternoon, everyone. Welcome to the Assembly Committee on Commerce and Labor. Madam Secretary, please call the roll.
Assemblywoman Carlton. Assemblywoman Considine. Assemblywoman Dickman. Assemblywoman Duran. Assemblyman Flores. Assemblyman Frierson. Assemblywoman Hardy. Assemblywoman Kasama. Assemblywoman Martinez. Assemblywoman Marzola.
Here.
Assemblyman O'Neill.
Here.
Assemblywoman Tolles.
Here.
Chair Hadigi.
Here. Madam Secretary, please mark the members who are not present absent excused. They have already advised me that they would be showing up late because they are presenting in other committees. Welcome to those who are here present in Carson City and those joining us online. Welcome to the Committee on Commerce and Labor. I will do just some quick housekeeping. Please remember, members and those here, to silence your electronics. Also, please note that members of this committee will be using their laptops to view exhibits, view bills. It's not a sign of inattention or disrespect. I would remind everyone that all exhibits or amendments are due by noon the day before the committee meeting. And we do require all those who would like to participate on Zoom or give testimony or be here in person to register online at the legislature's website. And the last reminder, those who are joining us on Zoom, please remember to keep your cameras on. That's the only way we can see you and know that you are with us. With that, we do have an agenda of 4 bills that we will be hearing today. I will be taking them in order with the exception of Senate Bill 303. I know that Senator Brooks has somewhere else to be, so we will be taking Senate Bill 303 first. Then we will move and take the rest of them in numerical order. Senate Bill 44, Senate Bill 181, and then Senate Bill 217. So with that, I will invite Senator Brooks to join us, and I will open the hearing on Senate Bill 303, which revises provisions relating to professions. Welcome, Senator. Thank you for joining us, and when you are ready, the floor is yours.
Good afternoon. Good afternoon, Chair and members of the Assembly Committee on Commerce and Labor.
Senator Brooks, is your mic on?
It is. I just got to get a little closer to it.
Okay, thank you.
So good afternoon to Chair and members of the Assembly Committee on Commerce and Labor. I'm Chris Brooks from Senate District 3 down in Clark County. And today I will be presenting Senate Bill 303. Over 20 years ago, I started one of the first solar electric companies in the country, and the first one here in Nevada. I installed the first net metered system in Nevada and have owned a solar net metered home for nearly that entire time. Restoring the rooftop solar industry and providing Nevadans with ways to create their own energy was one of the reasons I wanted to become a legislator. Since we, in this committee, through Assembly Bill 405, an Assembly Bill in 2017, we fully restored the residential rooftop solar in 2017 legislative session, the demand has skyrocketed. With that increased demand has come the increase in bad actors in that industry. In 2017, the legislature also put in place many consumer protections that have become a model for the rest of the nation, but more needs to be done to protect consumers. I'm sure most of this committee has been approached by salespeople, been called or received text messages, have been bombarded with online ads, and have had their mailbox full of advertising for solar. Many of these people and companies are unlicensed and are misrepresenting themselves to Nevada's consumers. Some have posed as government agencies or even the electric utility. Some have even referenced the law that we passed in this committee to say that Nevada law requires you to get their product. Many even claim free energy and non-existent state rebates. I had 2 young men come to my door right after 2017 legislative session to tell me all about this law that required me to get solar now. And so I invited them in for a cup of coffee to hear all about it, and quickly got on the phone with the Bureau of Consumer Protection. In addition to deceptive advertising, some of these companies are taking Nevadans' monies in the form of huge deposits and never performing the work. Senate Bill 303 aims to stop these practices and protect consumers. The majority of residential rooftop solar companies in Nevada are ethical companies that provide a high-quality product. I appreciate all the help that they have provided in crafting this language. I have worked very closely with the Nevada State Contractors Board, the Public Utilities Commission, and the Bureau of Consumer Protection while drafting this bill. This bill is based on a consensus with the Contractors Board, those other agencies, and the residential rooftop solar industry. If it pleases the chair, I would like to turn it over to Mr. Tim Geswine, the General Counsel for the Nevada State Contractors Board, to walk through some of the provisions of the bill. And also on the line, we have the Executive Director of the Nevada State Contractors Board, Margie Green. And so, Mr. Geswine, Chair, would it be okay if Mr. Geswine goes into some of the provisions of the bill?
Absolutely, Senator.
Thank you.
Good afternoon. As mentioned, my name is Tim Geswine. Perhaps I think it might be wiser if Executive Officer Green spoke first. She has some overall comments that might help illuminate these matters, if I might yield to her.
Absolutely. Ms. Green, when you're ready, the floor is yours.
Thank you, Senator Brooks, and good afternoon, Chair Hodegui and members of the committee. My name is Margie Green, and I'm the Executive Officer for the Nevada State Contractors Board. I'm here today to testify in support of Senate Bill 303, which aims to enhance protections for consumers engaged in the installation of residential solar systems. The Contractors Board has worked with Senator Brooks on the language of this bill and agrees this is an industry where additional safeguards are necessary. Legislation passed in 2017 and 2019 have helped encourage the residential solar market, with the highest number of solar installations being realized in 2019. According to the Solar Energy Industry Association, there are currently over 84 solar companies employing over 7,000 workers across Nevada. The increase in solar activity has led to consumer protection concerns regarding misleading sales practices, unrealized energy savings, financing and down payment practices, and related workmanship issues. Since 2016, approximately 4% or 331 of the licensed complaints received were against solar contractors. And of the 226 licenses revoked during this period, 21 or 9.2% were solar contractors. The damages validated through the recovery fund process best illustrate the board's concern for the public's welfare and safety. Since 2016, 275 residential recovery fund claims have been awarded to homeowners, totaling over $3.1 million. Of this amount, 174 of the claims were against solar contractors, totaling over $767,000. This represents 63% of the total claims awarded and approximately 25% of the total awards paid. It is important to note that the total amount of awards would have been greater if not for the monetary limitations in place for the recovery fund. At issue in several cases is acceptance of large down payments, some even requesting full payment up front, as high as $50,000, followed by project abandonment or substandard workmanship. The language before you today closely aligns with the statutes and regulations adopted back in the 90s and early 2000s, where similar issues were noticed within the pool industry. It is our belief that by enhancing the requirements and expectations of contractors engaging in residential photovoltaic projects, we will begin to see a noticeable decrease in the number of complaints being filed with our board. Consumers will be afforded greater access to information before making their decisions. They will be more adequately protected with regard to financial options and down payment limitations, and they will proactively be made aware of their right to file a complaint with the Contractors Board in the event issues arise with their project. Additionally, it will help to provide a more standardized contracting practice within the solar industry, allowing to hold the board more accountable and ensuring consumers are treated fairly throughout the residential solar process. And at this time, unless there are any questions, I would like to turn it over to the board's general counsel, Tim Geswine, to walk you through the bill.
Thank you, Ms. Green, for joining us. Mr. Geswine, when you're ready.
Thank you, Chair, and good afternoon. My name is Tim Geswine, and I'm an in-house attorney for the Nevada State Contractors Board. I'm going to address 6 areas to highlight regarding SB 303. Section 5 of the bill, as shorthand, defines what type of work is being addressed by the bill. Essentially, Anyone that builds a residential solar photovoltaic system or supervises such construction will be subject to the statute. Now, importantly, the definition was developed to allow Nevada homeowners to continue to seek information regarding solar photovoltaics without mandating that their educational source be a Nevada contractor. Section 7 of the bill requires anyone that builds a residential solar photovoltaic system to obtain the required building permits, to comply with the board's statutes and regulations, and to meet the requirements imposed by the Public Utilities Commission or by any electrical distribution system to which the residential solar photovoltaic system will interconnect. These requirements are important for compliance with Nevada's public policy goals, as well as electrical system safety. Section 9, subsection 2 of the bill outlines the requirements for construction contracts for residential solar photovoltaic systems. It's expected that this listing of information will reduce confusion by Nevada homeowners as a contract for residential solar photovoltaic systems. Section 10 of the bill requires all advertisements and solicitations for work regarding residential solar photovoltaic systems to be truthful and not materially misleading. The section also requires the Nevada State Contractors Board to create regulations regarding the solicitation or sale of contracts to perform this type of work. Section 12 of SB 303 prohibits enforcement of a contract to construct a residential solar photovoltaic system if the homeowner does not agree to the financing or if the homeowner rescinds the financing as allowed by the Truth in Lending Act. Lastly, Section 14 of SB 303 establishes that violations of the Act will make the contractor subject to discipline, may be reported to the Office of the Attorney General's Bureau for Consumer Affairs, and provides ramifications for the unlawful construction of residential solar photovoltaic systems. That concludes my review of the highlights, and if asked, I'm happy to answer any questions.
Thank you, Senator. Can we go to question and answers now, or do you have other co-presenters?
Excuse me, I also have, just to make some brief statements from the solar industry, I have Sarah Birmingham from the Solar Electric Industries Association, I believe is on, and then I also have Mr. Stephen Lassiter from Sunrun, which is the largest solar company here in the state of Nevada.
Okay, why don't we go to Ms. Birmingham first?
Great, thank you so much. Good afternoon, Chair Ahodavi and the Assembly Commerce and Labor Committee. My name is Sarah Birmingham, and I'm here representing the Solar Energy Industries Association. We're the National Solar Trade Association, and I'm here today testifying in support of SB 303. We've seen a lot of growth in the solar industry in Nevada, especially after the 2017 legislation that Senator Brooks referenced. And that legislation really restored the market, and we want to ensure that that growth in the solar industry happens in a responsible and ethical manner. Residential solar relies on word of mouth for success, and consumers who understand what they're receiving are likely to have a positive experience. However, misleading claims and bad actors are only going to poison those consumers' experiences with solar, and then they're going to tell their families and friends and neighbors, and we really want to ensure that these bad actors do not dampen our industry. And so we really appreciate Senator Brooks bringing this issue to the legislature. And I think that other states will be looking at this legislation as we move forward. We at SEIA are strongly committed to consumer protection, and we're continually developing resources designed to safeguard customer rights and providing stakeholders access to a lot of relevant materials, such as a SEIA solar business code. We've also developed residential guides for consumers to look at so that when they receive a bid, that they will understand what they're looking at and can look at issues from an apples to apples comparison. But all of the work that we do at the National Solar Trade Association is really important that our efforts complement the hard work of legislators and regulators. So we really appreciate the partnership that we had with the Nevada State Contracting Board and the Bureau of Consumer Protection on this bill. They've been very, very helpful in smoothing out any issues that we did have. And we really feel that the bill is in a very good place. And so I'm here today testifying in full support of the bill. This concludes my testimony, and I'm available for any questions. Thank you.
Thank you. And we can go to Mr. Lassiter next, Senator. Okay, Mr. Lassiter.
Thanks so much, Madam Chair, members of the committee, and to Senator Brooks. Thanks for the opportunity to comment today on this important legislation, which Sunrun supports. My name is Stephen Lassiter. I'm a senior public policy manager at Sunrun. As Senator Brooks mentioned, Sunrun is the largest residential solar company in the state of Nevada and also nationally. And our mission is to create a planet run by the sun. Our office, warehouse, and national training center is in Henderson, where we employ several hundred Nevadans. We have 15,000 customers across the state and more than 500,000 nationwide. Because we have long-term relationships with our customers, their satisfaction and having a positive customer experience is critical to our success as a business. We definitely want the industry to have a positive reputation in the state and in every state and to be free of bad actors. Consumer protection is a key priority for our company, and for that reason, we're pleased to support SB 303 and greatly appreciate the opportunity to have partnered with different state policymakers in its creation. That concludes my remarks. Thanks again to the committee and to Senator Brooks for your leadership and allowing us to comment today.
Thank you, Mr. Lassiter.
Thank you, Madam Chair. And that is all I have for testimony, and would like to open myself up for questions.
Okay, thank you, Senator. And I do have a couple questions, but I'm going to go to committee members first to see if they have any questions. Okay, perfect. I'm going to start with Assemblymember Considine, and then we will go to Assemblymember Dickman.
Thank you, Madam Chair. Thank you, Senator, and everyone else who brought this bill. I think it's a great bill. I just want to make sure that the wording in Section 5, subsection A, that all of the work that is done solar-wise on a customer side of electric meter means it has to be attached to the meter. So if I buy solar lights that I put in next to my driveway that are not attached to the meter, or something solar on like my doghouse for a fan, that's not in any, that doesn't fall under this. These are just for anything that's hooked up to the electric meter to the house?
That is correct. This through you, Chair, to Assemblywoman Considine. This is applies to, if you look at Section 4.7, the work applies to a residential photovoltaic system, which is a distributed generation system, as that term is defined in NRS 598.9804, which references back to the earlier piece of legislation that we were talking about, that it's a solar electric system that creates electricity that's then tied into your electric distribution system. So no, it wouldn't be any of these standalone lighting or fans or anything that wasn't creating electricity to go into the distribution system.
Thank you very much. Just wanted to make sure that there were still projects we could do.
Assemblymember Dickman.
Thank you so much, Chair. This is kind of a, I hate to even have to ask the question, because Section 8.2, I mean, is this something that's happening? A lot of contractor has to be told to complete the work diligently and not refuse to perform it? Seems like common sense, right? But we have to say this in statute?
Through you, Madam Chair, to
You can go directly to the members, Senator.
Thank you, Chair. Unfortunately, it is something that we have to that we have to say, because there's and not just this industry, in a lot of different industries, but it has come to this industry where there are a lot of folks who come and take consumers' money, and generally it's the consumers who are the most vulnerable, whether there's a language barrier or some sort of inability to read or discern the contracts, and they take their money and don't do the work. And so we unfortunately do have to make it very explicit that they have to complete the work, and this is the manner by which they can contract it.
Thank you. I just agree. It's sad we have to do this, but so with this bill, will it be easier to prosecute those people
Assemblywoman Dickman, absolutely. And what this kind of does is it ties together the deceptive trade practices issues around the trade and the contracting license issues, and it ties really those together in statute so that if a contractor is working with a third party who is using deceptive trade practices to get a customer, that contractor then is responsible as well as that third party. Before they were kind of seen in silos, and so you couldn't go after one if this one did the bad thing to the consumer, or vice versa. So it's this really kind of ties it together so that if somebody is representing themselves to you, that they can provide you with a solar product. At the end of the day, all those involved in that party need to be part of that contract.
Thank you so much, and
Thank you for the questions. And Ms. Dickman, Section 14 actually covers the violations of if someone's in violation of the provisions of this bill. But I'm going to jump in really quick just because I had the question on the same section. I just want to make sure I'm reading it correctly, Senator. It was that same sub 2 from Section 8 that they must complete the work diligently and shall not refuse to perform any work agreed to in the contract for any 30-day period. And it's just with that last part. Where it says shall not refuse to perform any work agreed to in the contract for any 30-day period, that basically means that they can't go more than 30 days without performing any work, right? So they have to perform work within 30-day periods.
Yeah, yes, Madam Chair, that's exactly what it means. And so what we saw are people signing contracts, taking deposits, and then being gone for unlimited amounts of time. And so this makes it so that once you've agreed to a contract, now work doesn't mean it has to be completed. Work can be, for the purposes of this, delivery of materials. It can be there's stages to every construction project, but we just want to make sure that these folks aren't just disappearing on you and not coming back for months and months and months at a time. And unfortunately, that's another thing that's happening out there.
Okay, thank you. And with that, I'm going to go to Assemblymember Tolles.
Thank you so much, Madam Chair, and thank you, Senator, for bringing forward this legislation. I really appreciate it, and I appreciate the need for it, absolutely, as we've seen these kind of practices abused by bad actors in the past. And so this is a little bit out of the scope, but I know in the past you've sponsored I just had it in my head, but a Solar Bill of Rights. Thank you. And I was just trying to remind myself. I think it was AB 405. Is that correct? And so I was just curious to know how these two work together in conjunction.
Thank you for the question, Assemblywoman Tolles, and thank you for helping me pass that bill in 2017. And that bill created it tied the deceptive trade practices and of the company, and it created a private right of action if those companies were having deceptive trade practices. This bill actually references back what exists in 624. I think it's NRS 624 that governs contractors, and then it ties it together in 598. I want to make sure. Yes, NRS 598 that governs deceptive trade practices, and it marries those two together so that you can't have one party come into your door and saying, "Hey, I can get you a solar system," and then the contractor shows up, and the contractor can say, "Well, I didn't know anything about this." Like if they're representing to you that they represent a contractor, then the contractor under 624 and under 598 should be held liable for any dishonest or unworkmanlike or unethical behavior. And so this absolutely marries the contracting statutes basically to the deceptive trade practices when it comes to residential photovoltaic solar systems.
Thank you. And I believe I saw that in Section 14, where it references that 598, Section 14, subsection B, under the deceptive trade practices. And I have a note here that it's also in subsection 5 of Section 8 as well. So I figured this looked familiar, and I appreciated how it completed the puzzle. And thanks for explaining that for the benefit of the committee.
Oh, thank you for the question, Assemblywoman Toles. If we knew then what we know now.
Thank you, Assemblymember. And members, any other questions? I'm going to go to Assemblymember Kasama.
Thank you, Senator Brooks again, Assemblywoman Kasama, District 2. So my question is, maybe you could just give me, it's page 7, which is section 9K. So it kind of talks about the retroactive, provisions. Could you just kind of explain how that might work since it's going back retroactively? Because there's a section that talks about, you know, the font size in the contract and if somebody's already signed one, and how do you see that working?
Thank you for the question, Assemblywoman Kasama, and I think I might have to refer to Mr. Gesswein on that one. And this is section 9, sub 2K. Is that what we're looking at?
Good afternoon. Tim Gesswein for the Contractors Board. Yeah, so in section 9, sub 2, sub K, there is a provision regarding reference back the contracts executed before October 1st, 2021. And that's regarding the schedule of payments, so that if there was a payment established in a contract before this October 1st date, there is a way to morph those around. And it gives us the board instruction on how to do that and participants to the contract on how to do that as well.
So it only has to do with the payment schedule going back retroactively to make it in compliance with this bill?
Yes, as I read it, is regards to the schedule of payments, which is in many of these situations one of the most difficult aspects of the misunderstandings between the participants to the solar photovoltaic system contract is what's due when and when are the benefits going to be achieved and those types of things.
Thank you.
Okay, members? Okay, most of my questions were asked, Senator, so I just have one question left, and again, more of a clarifying question, but I do just want to say thank you for adding in, looks like it's, let's see, what section is this? I think it's section 9, sub 4M. Oh, 9, yes, 4M. We heard a bill like this brought by one of our assembly members, Considine, about contracts and languages, and so I just wanted to say thank you so much for adding that in, that if the contract is presented in a language other than what it's written in, they can request it for it to be written in the language that it's presented in, so thank you for that. And then my other question was just on section 7, sub 2. I just need to make sure I'm understanding this correctly, where it says if a contractor performs a work concerning a residential solar system under the direction of a builder who is also the owner of a single-family residence, is this referring to a builder, like a development builder who's building a subdivision because they own the homes, or is this referring to an individual homeowner who also happens to be a builder? And because I know at the end of that, it kind of transfers all of the burden to the owner of the residence, saying that they must report the names and license and information concerning the required bonds and issuance with respect to the contractor doing the work. So I just wanted to see if you could help me clarify whether it's a owner of a subdivision or developer or an individual owner.
I believe it refers to an owner-builder scenario where it's an individual owner that's doing acting as the prime contractor on their own project, but I'll defer to Mr. Gesswein to make sure I'm not wrong.
Thank you, Senator Brooks, and thank you, Chair Tim Gesswein from the Contractors Board. Senator Brooks is absolutely correct. Section 7, subsection 2 refers to what is colloquially known as the owner-builder exception, which is an exception to NRS 624. It's 624031 sub 5. That allows the owner of a single-family residence to perform some work on the owner's own property. While a residential solar photovoltaic system would be beyond the grasp of most ordinary homeowners as compared to, say, a landscaping project or something like that, where a permit would be required. Nonetheless, it's wise to include in the bill a provision that says, should the owner of the residential single-family residence undertake as an owner builder, they still have to meet these obligations regarding building permits, requirements of the board, as well as the interconnect and PUC requirements. And that can't be avoided by hiring a consultant or something like that, that there's still these obligations must be obeyed.
Thank you so much. That fully answered my question, and it's similar to when an owner builder does a pool project. That just completely brought everything back. So thank you. Members, last call. Okay, Assembly Member Kasama.
Yes, I forgot I had another question here, Assemblywoman Kasama, District 2, Senator Brooks, under section, it's page 7 again, so that would be 9(2)L. So the section there that says, produce electricity provides for payment of a commission to a salesperson out of the contract price. The payment must be made pro rata. So why do we have that in here? Because I don't think there's any similar type, let's say, for a salesperson for a car sale. So when that car is sold and that person goes on a payment schedule for the car, the salesperson is paid the commission up front for putting the contract together. And so here, this seems to be adding a lot of paperwork and accounting to now the salesperson's commission for bringing the contract together is paid based on the payments from the owner, and I don't think any other industry is doing that. So that seems a little concerning to me.
Thank you, Assemblywoman Kasama. And what we're seeing happening, and this is similar to what happened in the pool industry in the 90s, and that's why you'll see a lot of this mirrors statutes that are currently in place for the pool industries. But you would see a salesperson say, I'll use just some round numbers, for $50,000, we can do a solar system for your house. Or they would say for $200 a month, you can have a solar system for your house. They would then require deposits from you, the consumer. And in the case of the $50,000, they could require a contract from you and a deposit. And so we want to make sure that work was being delivered and work was being done. But in the case of the $200 a month, they aren't getting any cash from you. They are getting you to sign on the dotted line for sometimes a high interest long-term financing deal, or sometimes a power purchase agreement or a lease or any of these things. They then are going to take that and sell it to a financing company and a contractor. They're going to negotiate with this financing company and the contractor. They are going to then get their money up front and be gone. And what this does is this ties the salesperson to the performance of the contract. So if a salesperson, even if there's no money that changes hands immediately, because it's going to be a zero money down, 4.99 forever deal, we want to make sure that until you get your product completed, that nobody is getting all of their money. Like, we want to make sure that we're marrying those two business activities together, because that's where we're seeing the most fraud.
And you said that this mirrors for the pool industry?
I don't know if this provision exactly mirrors the pool industry, and Mr. Guesswine or Ms. Green could answer that, but this is where that came from, and it's very similar to what had to be put in place in the 90s, because the same exact behavior was taking place.
Do we know what that section is?
Ms. Green, Mr. Guesswine, if you don't have that handy, if you could just provide it to the committee or the committee manager at a later time too, and we can distribute it to the committee if it's not something. Oh, and Ms. Kasama, it looks like our legal actually was able to find that, and so you can find that in 624.290. Thank you, Mr. Quast. And members, that was 624.290. Thank you, Mr. Quast. Okay. Okay, members. Okay, at this time, I will move us into testimony in support of Senate Bill 303. Is there anyone here in Carson City wishing to testify in support? Okay, seeing no one here in Carson City, is there anyone on Zoom? You can just raise your hand and Okay, broadcasting, could we check the telephone line for anyone wishing to testify in support of Senate Bill 303?
To testify in support on Senate Bill 303, please press star 9 now to take your place in the queue. Chair, there are no callers for support at this time.
Okay, thank you. Is there anyone here in Carson City wishing to testify in opposition to Senate Bill 303? Okay, seeing no one signed in on Zoom broadcasting, can we please check the telephone line?
To testify in opposition on Senate Bill 303, please press star 9 now to take your place in the queue. Chair, there are no callers in opposition at this time.
Thank you. Is there anyone here in Carson City wishing to testify in the neutral position? Is there anyone on Zoom wishing to testify in a neutral position? Okay, broadcasting, if we could check the telephone line.
To testify in neutral on Senate Bill 303, please press star 9 now to take your place in the queue. Chair, there are no callers in neutral at this time.
Okay, thank you. And members, I just do want to clarify something. I quickly spoke without reading correctly, and the chapter is actually 624.940. I omitted that 4, so it's 624.940, so I apologize for that. With that, seeing no closing remarks are necessary, I'm going to go ahead and close the hearing on Senate Bill 303. Thank you, Senator. Okay, welcome, Senator Gokachia. Looks like we have you for a bit with us today. Members, I will now open the hearing on Senate Bill 44.
Thank you, Madam Chair. Thank you, Madam Chair, members of the committee. I'm actually going to just introduce 44. This bill on the Senate side, we adopted, we were up against the deadline, attempted to adopt an amendment to it. It didn't get us where we needed to be, so working with Chairwoman Spearman from Commerce and Labor on the Senate side, we agreed we'd pass the bill out, send it over here, and so I'm here today, this afternoon. I believe you should have a mock-up amendment 3325 to Senate Bill 44. It should be in Analyst. I will say one thing, Senate Bill 44 is a phone book, and I'm not going to even attempt to walk through it. I do sit on the Northern Nevada Regional Behavioral Health Board, and that's why I am actually involved in this. The bill will be presented by Valerie Chape Haskins, who is the Executive Director of the Northern Nevada Regional Behavioral Health. And so really all I can say to the bill, it's really necessary. It facilitates licensure for a broad gamut of drug counselors, therapists, and trying to clean this up to actually how we can shorten it, what is required in the transcripts, how you can actually get a provisional license. And definitely we all know across Nevada there is a need for, especially as we deal with behavioral health. So with that, I would prefer, in the interest of time and hope that brevity, that Ms. Chape Haskins will go ahead and present SB 44. Thank you, Madam Chair.
Thank you, Senator, and welcome, Ms. Chape Haskin, when you're ready.
Good afternoon. Thank you so much for this opportunity. I'm getting ready to share my presentation here. All right. Is that coming through okay?
Yes,
All
and
right.
if we could just stick the PowerPoint, Ms. Chape Haskin, if you could just stick to the highlights. We do have a heavy agenda today, and I lose members to another committee. So if we could just do a high level overview, and then maybe just walk us through the amendment, please. Thank you.
Will do. I will try my best. So again, good afternoon. For the record, this is Valerie Quape Haskin. I am the Rural Regional Behavioral Health Coordinator. I am presenting today on behalf of the Rural Regional Behavioral Health Policy Board, which represents 6 rural counties, including Elko, Eureka, Humboldt, Lander, Pershing, and White Pine. My board chair was unable to truly connect today, but he is on the line listening in. And thank you, Senator Goycochea, for that introduction. So our goals for today, I just would like to briefly run through some of the behavioral health provider shortage issues that we experience here in Nevada, talk about the purpose of this bill and what the board would like to accomplish with SB 44. I will also quickly run through the current language that is posted to Analyst, as well as this amendment mock-up that we have put forward as well, and then open it up. So as you are aware, and you've probably heard in previous committee meetings, there are way too few licensed behavioral health professionals in Nevada. And when we say behavioral health, what we want to clarify here is that we, for the purpose of this bill, are talking about mental health separately, substance use separately, and those two co-occurring. In the past or throughout, so it's come to the attention of the Rural Regional Behavioral Health Policy Board, as well as being voiced by local stakeholders, that when experienced behavioral health providers move to Nevada, this process of them achieving licensure here in Nevada, which is called licensure by endorsement, based on their previous education and experience, can sometimes take months and in some cases even years. Throughout 2020, we maintained contact with local stakeholders who indicated that the need for behavioral health providers really escalated during the pandemic. And while telehealth and other means of connecting consumers to providers had improved access to those existing providers, there is still simply not enough providers in Nevada to meet the current need. Also, there are some community members who may be experiencing behavioral health challenges for the first time ever, rather than those who are just falling out of stabilization from existing illness. And so it's likely that the needs for an increase in providers may last well after the pandemic is over. Oh, let me see here. All right. So this map and the data presented in the graphs in the next 4 slides are from the 10th edition of the Nevada Rural and Frontier Health Data Book, published by the Office of Statewide Initiatives at the University of Nevada, Reno School of Medicine. This first map shows areas within the state which have been designated by the U.S. Health Resources and Services Administration, or HRSA, as shortage areas for mental health providers specifically. There are several different factors that go into this score, but as you can see from this map, almost the entire state falls as a high need shortage area. So while this bill is being put forward by the Rural Regional Behavioral Health Policy Board, it really does benefit the entire state. The data in this graph represents 4 different types of providers together as a whole: alcohol and drug counselors, licensed clinical alcohol and drug counselors, certified problem gambling counselors, and licensed alcohol and drug counselors. The data here and on the following slides is presented as the number of providers per 100,000 persons in the population, since that's really the easiest way to compare the adequacy of the pool of providers across counties of different sizes. As you can see, while most of our rural and frontier counties have low numbers of providers, so does Clark County. A word of caution, however, with this type of data, in the counties with the smallest populations, you're going to see the greatest variety in the number of providers when using this per 100,000 population. So Esmeralda is a really great example here. That 100 providers per 100,000 population is literally one person. So if that person decided to move, retire, or otherwise no longer serve that county, then that number would go to 0. So you'll want to keep this in mind as we move forward through these next slides as well. In this graph, the number of marriage and family therapists, or MFTs, is represented in blue, while the number of clinical professional counselors, or CPCs, is represented in orange. Again, we see many counties without adequate coverage and some with no providers at all. These deficits are further exacerbated when we look at the number of psychologists available. Please note that the scale on the y-axis here is much different than the 2 previous graphs. While Carson City and Washoe County appear to have a comparatively good access to psychologists, those higher numbers are actually the same as the lower numbers in previous graphs. We just have a much greater deficit of psychologists available in the state. While the numbers of licensed clinical social workers, or LCSWs, available is somewhat better than other types of providers in Nevada, the disparities in Nevada really continue throughout. So, as a means to fill gaps in all forms of healthcare during the pandemic, the Governor's Directive 011 allows licensed medical and behavioral health providers from out of state to skip the majority of the licensing processes in order to begin serving Nevadans. With this directive, the process is undertaken by the behavioral health licensing boards to get these professionals Nevada licensure by endorsement has gone from sometimes months to a matter of a few days. So it can be done. Furthermore, I reached out to the 4 behavioral health licensing boards in January and asked them how many consumer complaints they had received against providers licensed under them since April 1st, 2020. And then of those, how many providers were practicing here under the Governor's Directive 11. At that time, while they had received more complaints than normal, none of those complaints were regarding providers practicing under the emergency directive. As 2020 marched on and the time arose for the Rural Regional Behavioral Health Policy Board to build its BDR for this session, it was decided to address the behavioral health licensing boards by affecting NRS to streamline the processes for licensure by endorsement. So in other words, what could we do to keep the improved effects of Directive 11 in place long term? And more specifically, how could we do that by increasing the number of behavioral health providers available to Nevadans in need of care? Just as we've defined what we mean by behavioral health in this presentation, we also want to define what licensing boards would be affected by the bill. So the boards affected by SB 44 include the Board of Psychological Examiners, the Board of Examiners for Marriage and Family Therapists and Clinical Professional Counselors, the Board of Examiners for Social Workers, and the Board of Examiners for Alcohol, Drug, and Gambling Counselors. And this is a big part of the reason why the bill is so large, is because it changes language in similar places for all 4 pieces of NRS. So that is a lot of what creates the length. So let's briefly walk through the process that was used to develop the bill. So my board chair, and I worked throughout 2020 and into 2021 to build out the original concepts of the bill, as well as to seek necessary revisions. We did this by utilizing feedback from a large group of stakeholders to identify what parts of the original bill language needed to be amended to have the greatest benefit of and impact, which is essentially the amendment that you're going to be seeing today. When all was said and done, we had a list of approximately 45 stakeholders, 25 to 35 of which consistently showed up to meetings. These stakeholders were from a broad variety of aspects of our behavioral health system in kind of a larger means. And each meeting was recorded and posted to YouTube, so anyone who was not able to participate would have the opportunity to review its contents. So now that we've gone through the background of the bill, purpose, and development, let's go ahead and review the components. So as the bill language stands without any amendments, there are 3 main concepts included in the bill. First is the addition of the Licensed Master of Social Work, or LMSW licensure type, to those offered by the Board of Examiners for Social Workers. Nevada is currently one of only 5 or so states that do not offer this type of licensure, and that makes it very difficult for the Board of Social Work to enter into interstate compacts for licensure reciprocity without having this licensure type. While licensure by endorsement is great, licensure reciprocity through interstate compacts really expedites this process and helps improve communication as to the quality of providers. Furthermore, without offering an LMSW licensure, there are no professional designation differences for licensure between social workers who hold a bachelor's degree and those who hold a master's degree. Thus, the addition of the LMSW provides the opportunity for social workers who have taken that extra step to complete an improved advanced degree in social work to have that professional distinction. This also serves as an intermediate step between a bachelor's levels. This language was developed by the Board of Social Work itself and also allows for current LSWs licensed in Nevada who hold a master's degree to very quickly just streamline over to the LMSW licensure type without submitting any further documentation if this bill is passed. Second, the current language allows for a provisional license to be granted to new licensees and those who would seek licensure by endorsement upon submission of their unofficial transcripts instead of just their official transcripts, while waiting institutions to take care of this paperwork. Initial conversations led us to believe that this was one of the big holdups in licensure processes. However, as you'll see shortly, we're going to be amending this piece to have greater impact. Lastly, because specific mechanisms that were causing delays in licensure by endorsement couldn't be pinpointed in larger work group meetings, The current bill language includes an interim study by the Interim Committee on Healthcare to evaluate the processes of the licensing boards to identify unnecessary barriers to licensure. This is also something that is being amended out. So issues with the current language, we brought those back to our community group, and what we found was the results of the interim study wouldn't have any effect on licensure processes until the next legislative session in 2023. So there was a lot of people who voiced their concerns that this was simply too little, too late, and more immediate change was needed. Also, it came to light that with lags in the submission of official transcripts, it was really only a major issue during COVID, and that ultimately getting the results of fingerprints and through background checks submitted for back to the boards was something that was more of a long-term problem. Additionally, the opportunity for new graduates who are wanting to complete their practice hours for licensure is something that affects all rural and frontier communities, essentially by the number of supervisors who are available to take them on. I've tried personally to help connect some interns with supervisors as I can, but this is a reoccurring issue that is experienced by my board members, other partner organizations, and many local residents. While this doesn't necessarily affect licensure by endorsement, it does affect the number of providers available to practice in rural communities, as interns often have to either move to more urban parts of the state or out of state entirely to complete their work to become fully licensed. So it was requested that we look into what we could do to include this piece in our bill. In early April, Senate Committee on Commerce and Labor voted to amend and do pass SB 44 with the concepts as proposed during that work session. Unfortunately, the amendment itself hadn't been released on Nellis previous to the vote on the Senate floor, and so there had been some concerns previously. The amendment was retracted, as Senator Goycochea mentioned, and the bill was voted off the Senate floor. So you should have the mock-up in front of you, and we'll be going over that. So let's run through these amendment concepts. So first, my board would like to remove the interim study on the licensing board's processes and their efficiency because this is no immediate changes are made from there. Instead, the board wishes to revise the language in NRS for all 4 of the licensing boards regarding licensure by endorsement specifically. Affecting licensure by endorsement with this bill also achieves the goal of creating more immediate change rather than waiting until next session to affect licensure processes. Next, the board's proposing that the language regarding unofficial transcript submission be removed and rather replaced with language that provides for provisional licensure of providers pending the results of their fingerprint background check, if still pending after 45 days. The reason for this being that it expedites the process, and furthermore, the proposed language for licensure by endorsement already requires applicants to submit signed affidavits stating that they have not been convicted of malpractice, nor are they under current criminal investigation. So also there's at least one of the licensing boards affected here that does not currently have fingerprinting as a requirement in NRS, and this would help them codify this into their processes. It was also requested by members of the Senate Committee on Commerce and Labor that provisions be made to give alternative means for official transcript submission for providers whose schools have since closed or who have been absorbed by other institutions. It is our understanding that this is something that is also allowed by other states. At the beginning of each section of NRS regarding licensure by endorsement for each board, the current language states that each licensing board may grant licensure by endorsement to applicants given their qualifications, rather than shall. So the Rural Regional Behavioral Health Policy Board would like to strengthen that language by amending may to shall. This creates licensure as the default choice if there are any questions. All right. Currently, at least 3 of the 4 licensing boards have explored remote supervision possibilities for interns. It is our understanding that the Board of Social Workers has implemented this strategy on a part-time basis. The MFT CPC board was implementing remote supervision full-time when COVID restrictions were put in place, and that the Alcohol and Drug Board had also explored this option. However, at best, the provision of remote supervision options is only included in NAC, not NRS. The Rural Regional Behavioral Health Policy Board would like to amend the bill to ensure that licensing boards must provide remote supervision options for interns. The board would also like to amend the current bill language to provide a lower application fee for members of the armed forces, veterans, their spouses, and surviving spouses as a means to honor those who have served our country. We believe it is unlikely that the licensing board's income through collection of fees would be severely affected by the volume of applicants submitting applications submitted by qualified persons under this provision. With the proposed changes to licensure by endorsement, LCB staff noted that NRS could be streamlined by combining language regarding licensure by endorsement for both general population applicants, as well as those who are members of the armed forces, veteran spouses, and surviving spouses. So this change does not remove any benefits to licensure processes for applicants of the latter groups, but removes redundancy in the language as it would stand under this amendment. It was also asked in Senate Commerce and Labor that the affected licensing boards would be required to list crimes which would disqualify a potential applicant for licensure. It was decided that requiring licensing boards to list these crimes in regulation would allow the list to be updated as criminal laws updated and reformed. So looking at this kind of 40,000-foot view of the original language versus what we would like to see in the amendment, the bill will go from having three main components: the interim study, provisional licensure pending official transcripts, and the addition of the LMSW licensure type, to including 7 components: the revised licensure by endorsement processes, provisional licensure pending fingerprinting results, alternative means of official transcript submission under certain circumstances, remote supervision options, reduced licensure by endorsement fees for service members, veterans, spouses, and surviving spouses, improving communication regarding disqualifying crimes, as well as the previous edition of the LMSW licensure type. I tried to make that as brief as I could. Thank you so much. I really appreciate it. If you have any questions, please feel free to contact either my board chair, Fergus Loffridge, or myself. And with that, I'd really like to open it up for questions.
Thank you for your presentation. And Senator Gocochea, is there anyone else you would like to have give remarks?
No, thank you, Madam Chair. I think we probably need to push through this. I know we've all got a tight schedule.
Okay, thank you. Members, questions for Senator, for Mr., or for Ms. Haskin? Okay, I'm going to go to Vice Chair Carlton first.
Thank you. And I have a number of questions, but I think the most pressing question that I have is, boards are there for public safety and to make sure that appropriate people are licensed, and we know who's practicing in this state. So when you change the term from may to shall, you're actually cutting the knees off on the board, because then they don't have discretion to figure out if that's the right person that should be coming in the state. Yes, we all do want to get more people into the state, but we don't want to make them have to license someone if there are background concerns or other concerns. So by changing that may to shall, you are limiting the authority of the boards to take the 360-degree view of that licensee to make sure that there aren't any issues, because their transcript may be great. They may interview well, they come in, they do everything, but you could find out there may have been a Medicaid fraud issue in the past. That wouldn't fit within really scope of practice. But if they've committed Medicaid fraud and this says you shall give them a license, then we might possibly have someone here in the state doing something that we really don't condone. So I have serious concerns whenever we put the word shall, because we're limiting the board's discretion in making sure that the appropriate people are licensed in the state. So I guess I would need a little more conversation about that, because we have had problems in the past with people. If they're having problems in their home state, they will run to a state that they will make sure will give them a license. And if they read shall in here, they know that you will have to give them a license. So I just have concerns that we're going to limit the board's discretion if there's an issue with that particular provider. And did that topic come up?
No, I don't believe that. I know there was some dialogue between the may and the shall. Senator Goycochea, for the record, I don't think that's a deal breaker either way. If this committee feels very strongly about changing that, but I believe the subsequent applicant has to meet the requirements set forth in this section, which is, that you don't have any violations. It's an alternative way of providing the transcript. I realize that, but again, it should be acceptable. We thought we wrote enough protections in there to make sure that they were comfortable at that point with issuing a license. And again, clearly that's the intent of the bill, is to expedient the licensure. But again, if that's a deal breaker, I don't think it's critical for our side, whether it's may or shall. Clearly, I'm sure the board's going to do the best they can.
And thank you, Madam Chair. And not everything that can impact public safety is actually within the scope of practice. So there are other outlying things that could send up a red flag on a professional wanting to come into the state. So I just wanted to make sure that we had that on the record and that the boards had an opportunity to take a look at that, because, over the years, yes, we do want to get more professionals into the state, but the last thing we want to do is have the state put its faith and trust behind a professional that comes in and does harm to a senior, someone who's disabled, someone in one of our more vulnerable populations. The whole idea behind licensing boards is to protect the public, not to help the profession become more profitable or have more clients. That's what an association is for. So I just want to make sure that the board these boards have the opportunity, if there's a red flag, that there's a way for them to say, we don't think this person should be in our state.
Thank you, and thank you through the chair to Assemblywoman Carlton. More than willing to work with you on whatever is required there. Thank you.
Members, any other questions? Okay, Assemblymember Tolles?
Thank you, Madam Chair, and thank you for bringing this bill forward. I do know that it's just a great broad effort across the board to increase, access to these types of individuals, as well as to reduce barriers to entry. And so I commend you for bringing forward this bill. I wanted to just specifically touch on, in the amended version, section 2.5, subsection D, regarding prescribing lists of each crime for which a conviction disqualifies or may disqualify a person from obtaining a license from the board. And this body passed last session, AB 319, which created a pathway for individuals who have some sort of criminal history to be able to petition a board ahead of time before pursuing their licensure, to see if their particular crime might have a bearing on their ability to get a license. The reason that we went that route versus putting a list of crimes on a website was because there are certain crimes that would be obvious to all, but then it might open a door where, how long do you make that list? Do you make that list arbitrarily longer than it needs to be? Is it something that prohibits somebody on a case-by-case basis? For example, and this specifically came up in the process of that legislation last session, if you have somebody who is an alcohol or gambling counselor who is 20 years sober, 30 years sober, something was in their past 20, 30 years ago, actually helps to inform their practice and make them an even more effective counselor in that space. If you put that on a list on a website and that applicant just pulls up that list and says, oh, well, I'm out, we might arbitrarily lose somebody who could be a very effective professional in that space. So could you just talk a little bit more about the reasoning behind adding that in this amendment? Thanks.
Thank you, Senator Goycochea, for the record, through the chair. Again, I'm not the sponsor of this bill. I'm just trying to help it across the finish line. So I'll defer
Senator,
to Ms.
we can go
Haskin.
to Ms. Happy Haskin if you'd like. I see her raising her hand. Ms. Haskin?
Thank you. For the record again, Valerie Quape Haskin. So the reason why we put this in was really to piggyback on AB 319 from last session. And again, this was at the request of Senate Commerce and Labor, and that specific question did come up. The reason why they requested to see this piece in the amendment was because to ensure that someone had an idea as to, before they went to all the effort of completing the application process and submitting the licensure fees, having an idea as to whether or not they would even qualify or if there were disqualifying crimes. That's why we also decided to go with the listing in NAC rather than NRS, so that there would be more flexibility there. But again, we are definitely open to working on this piece as well.
Thank you, Madam Chair, and perhaps we can follow up on that because I do think that it might open up another can of worms that you're trying to avoid, and we do have that process in place for them to petition privately versus putting an arbitrary list on a website. Thank you.
Thank you, Assembly Member, for those questions. I remember that bill from last session, and I agree, and I think this might actually prevent someone from applying who might be eligible, and we're trying to expand the people who enter the field. Members, any other questions? Okay, I do have a couple, Senator, and these might be better for Ms. Kauhapi Haskin as well, so whoever would like to answer them. But I noticed in here we added, and I didn't see it in here, so it's new language to every single one of the sections about granting a provisional license 45 days if the background checks don't come back within 45 days. How long is it taking right now to get a background check? What's the normal time frame? And is the 45 days in line with what other licensing boards have, or how did you come up with that 45-day period?
For the record, again, Valerie Quape Haskin, Rural Regional Behavioral Health Coordinator. Thank you, Chair, for that question. So the 45-day piece was already something that was in statute regarding when the boards would need to make a decision or along the timelines of board dates there. So we just kept the 45 days. What is currently happening with fingerprints is it's sometimes taking a couple of months, so not much further past that 45 days. But if it's 2 to 3 months, then we're looking at 90 days, 120 days. Again, with that language, it's also important to remember that that provisional licensure expires after the boards receive the background check results and are then able to make a decision as to whether or not to grant full licensure to the applicant or to revoke the licensure application.
Okay, thank you for that question. And then just another question I have, I see that you guys deleted the section where it's requiring the board to submit a report to the Legislative Committee on Health Care, the number of applicants you guys received by endorsement, and then the number of people who were denied. Why are you guys choosing to no longer submit those reports?
Thank you again. For the record, Valerie Quape Haskin, Rural Regional Behavioral Health Coordinator. Thank you, Chair. The purpose there was not to remove the reports that are already being submitted, but to remove the interim study that was going to be done between the end of this session and 2023, and to close that out. So if we need to refine that language further, again, we're open to that.
Thank you. And I just have one more question, and then I'm going to go and back to my vice chair, but it was just, again, more clarifying question. I know you guys created language for applicants to submit alternatives to transcripts if the school they have gone to is no longer there and they're unable to obtain them. But how often does that actually happen? I mean, have you guys ever had an applicant who was unable to secure their transcripts because the school they went to no longer exists?
For the record, Valerie Quape Haskin, Rural Regional Behavioral Health Coordinator. Thank you, Chair. That's an excellent question. That was something that was brought up in Senate Commerce and Labor as something that had occurred. It sounded like more in like the broad medical community, and was a concern of some of the members in that committee. So at this time, it's unknown if that's really something that is a major issue. Again, I think that my board is willing to work with the committee on that.
Thank you. I appreciate that, Ms. Kauhapi Haskin. I apologize. Just merged your two names together. Okay, with that answers all of my questions. I would like to go back to Vice Chair Carlton now for questions.
And thank you, Madam Chair. So I think I'd like to get into the fingerprints a little bit more because this has been an issue for a very, very long time, and it's something we've tried to fix. And I think we've really made strides in the state with the central repository, moving forward and giving them the resources and being able to get that turnaround addressed. I believe the biggest stumbling block, and correct me, is the FBI background check. That's the one that takes the longest. So do you know, and maybe one of the boards can answer this, about where are we with the central repository turnaround time versus the turnaround time on the FBI background check?
For the record, Valerie Quape Haskin, Rural Regional Behavioral Health Coordinator. Thank you, Vice Chair Carlton. I appreciate that question. At this time, I do not have that specific information. However, I can look for that and get back to you.
And thank you, because I believe the central repository does a quicker turnaround. With the drop dead date of 45 days, if you get the central repository back, and keeping in mind, central repository only does within the borders of our state. They don't tell us that person's actions in another state. But if they're clean in our state, the thing is, the central repository report will come back absolutely clean if the person hasn't moved to the state yet. So that may not necessarily be the guiding light that you need. That FBI background check may be really where you need to be. And I guess I'm curious about the armed forces provision, that if they're an active member of the armed forces, they would not need to submit their fingerprints for verification of who they are. So the thought process behind, is it because they've already been fingerprinted that we wouldn't need to? But if there had been something that had happened from the time they were fingerprinted, and let's say there was a DUI charge, there was a drug charge, there was a sexual assault charge, in that time frame, then we wouldn't know that, because we would be taking a set of fingerprints that may be out of date, and we may not have been able to run a true record on that person. So what was the thought process behind that?
For the record, Valerie Quape Haskin, Rural Regional Behavioral Health Coordinator. So as we worked with Senator Spearman on this piece, as she is a veteran herself, she was able to provide some clarity as to some of the processes related to fingerprinting of active duty military. And active duty military are actually not fingerprinted, from what she mentioned, just once, but it happens on a fairly regular basis, and is associated with their security clearance. So if someone was to commit a crime that would show up on their record, it's something that would also be related to their discharge paperwork or be on their military record as well. And I believe that information, that documentation, is also a requirement for them to be licensed with that lower rate if they're going to apply as a service member or veteran, or is to include their record.
And I guess I'm just a little confused, because if they don't have to submit their fingerprints, how do we do the background check? How do we know what's happened in the recent past? So, but there may be more to this, the way the military does it, than I understand. So I look forward to getting clarification on that. I just want the board to be able to make sure that they know who this person is and what their actual history is. So thank you very much, Madam Chair. Appreciate it. And if I could ask a clarifying question. So in the presentation, so Senator Goicoechea, this mock-up that we're working on, this was not part of what passed in the Senate. This is being proposed as an amendment here in this committee right now. Do I understand you correctly?
Yes, to Assemblywoman Carlton, Senator Goicoechea, yes. We were up against the deadline. We went ahead and moved the bill out, 44 out, without any amendment to it. And it was agreed we'd try and bring an amendment on this side, and this is the conceptual.
Okay, thank you. I just wanted to make sure that I understood the process. And we all know what those deadline days were like, so thank you very much.
Thank you, Vice Chair, for your questions. I know I had some of the similar questions as well. Members, any other questions? Okay, seeing none, I will now move us into testimony in support of Senate Bill 44. Is there anyone here in Carson City wishing to testify in support? Okay, is there anyone on Zoom? Just a show of hands. Okay, broadcasting, if we could please check the telephone line for anyone wishing to testify in support of Senate Bill 44.
To testify in support on Senate Bill 44, please press star 9 now to take your place in the queue. Chair, there are no callers in support at this time.
Thank you. Is there anyone in Carson City wishing to testify in opposition? Okay, seeing no one signed in on Zoom. Broadcasting, can we please check the telephone line?
To testify in opposition on Senate Bill 44, please press star 9 now to take your place in the queue. Chair, there are no callers in opposition at this time.
Thank you. Is there anyone here wishing to testify in the neutral position to Senate Bill 44? Welcome, Ms. Foley.
Thank you, Madam Chair, members of the committee. My name is Helen Foley, and I'm delighted to be here today for the first time this session. I am here on another bill, but I represent First Med Health and Wellness, which is an FQHC in Southern Nevada. And as I was listening to this testimony, I really think we need many more mental health therapists in Nevada. However, the most important thing is that background check. And so in listening to Assemblywoman Carlton raise the concern about individuals who have not been adequately screened for that, we do not believe that they should receive provisional licensure until that is done. I mean, we want them to go to an accredited university. We want them to have the supervised hours, but we must have that background check. And so we would love to work with the sponsor and the committee as you continue to deliberate on this issue. Thank you so much.
Thank you, Ms. Foley, for your testimony. Is there anyone on Zoom wishing to testify in the neutral position? Okay, broadcasting, could we check the telephone line, please? Thank you.
To testify in neutral on Senate Bill 44, please press star 9 now to take your place in the queue. Chair, there are no callers in neutral at this time.
Okay, thank you, broadcasting. We appreciate you. Senator Gokachia, would you like to give closing remarks?
Just very brief. Thank you, Madam
got
Chair,
it.
members of the committee. It's been a heavy lift getting here. I don't know why it's as thick as it is, trying to accomplish something. It seems somewhat simple, but it's got to be right. I appreciate it. Look forward to working with you and the committee and see if we can maybe get it right before another deadline day. Thank you.
Thank you, Senator. And don't go too far. We have you up next. So with that, I will close the hearing on Senate Bill 44. Members, the next item on our agenda is Senate Bill 181, presented by Senator Gokachia. So I'm going to go ahead and open the hearing on Senate Bill 181, which revises provisions relating to alcohol and drug counselors. Thank you, Senator. Welcome back.
Thank you, Madam Chair. And members of the committee, Senator Goycochea representing Senate District 19, which does encompass a lot of rural Nevada. This is a bill I actually brought forward on behalf of a number of constituents and providers, and also the one that will actually really present the bill will be Ms. Sarah Adler. She's done a yeoman's work on getting this point, and it's a very simple bill compared to what we just dealt with. Again, pretty much the same arena. We're looking for providers. This does shorten up the academic hours, and with that, I will turn it over to Ms. Adler and look forward to any questions. Thank you.
Thank you, Senator. Welcome, Ms. Adler.
Thank you very much, Madam Chair and members of the committee. I am Sarah Adler with Silver State Government Relations. Today, very appreciative to Senator Gokachia for his continued work and support with my clients, Vitality Unlimited, based in Elko, and New Frontier, based in Fallon. These are two
long-serving, as you will learn, rural behavioral health and substance use disorder treatment organizations, Vitality Unlimited based in Elko and New Frontier based in Fallon. We very much appreciate, so here's the front page of our presentation, which I will move quickly through since you have a strong background in this work. But we present to you in SB 181 a very important and large step toward a very necessary solution, which is increasing the treatment workforce that's licensed to treat Nevadans suffering from substance use disorder and co-occurring disorders. As you'll learn here, we have an inequity in terms of the hours of supervision required for behavioral health licenses versus substance use disorder license, and we are asking your assistance. So you all are very familiar with the broad classification of substance use disorder. You are very familiar, sadly, we all are, with the incidence of opioid abuse in Nevada. Opioids have garnered our attention really all of these last 10 years, and while it appears that opioid deaths peaked in 2016, preliminary data from 2020 is not good. These two charts show us a 2.9% increase in all drug-related emergency department visits from 2019 to 2020, and a 26% increase in opioid-related emergency visits. And opioids, as you know, are not the only substances that Nevadans are struggling with. On this chart, which I appreciate the Office of Analytics providing to me, we see opioids, heroin, marijuana and hallucinogens, cocaine, methamphetamine, and methamphetamines. I myself have a long history working in rural Nevada and tribal Nevada. And when you talk with our tribal communities, they say absolutely, opioids are a very significant problem, but have you forgotten about meth? Meth is a very significant problem still in Nevada. And drugs are not the only addiction that we must be able to treat in Nevada. Alcohol addiction is also a very significant problem to a debilitating extent. This chart shows you inpatient admissions, and the blue line there is alcohol admissions, so a very large number that we need to be able to treat here in Nevada. Mental health disorders you are well aware of. The three classifications of mental health disorders are presented to you here. Fortunately, in Nevada, we have done a lot of work in mental health in the last many years. And then you're familiar with the term co-occurring disorders. That means that an individual has both a mental illness and a substance use addiction. For some, the mental illness is primary. For others, the substance use disorder is primary. So, as you've just heard from my friend Valerie, we have 4 behavioral health licensed professions that I'm going to touch on today. Here's our 4 chapters. And I want to introduce you specifically to those that are licensed by the Board of Alcohol, Drug, and Gambling Counselors. LADCs is the shorthand for Licensed Alcohol and Drug Counselor. This is someone who is required in statute to have a master's level of education, and right now 4,000 hours of supervised internship. This LADC treats individuals with substance use disorder or the SUD component of an individual with co-occurring disorder. Their partner is a licensed clinical alcohol and drug counselor. This, to me, is the gold standard that we need a gazillion more of throughout Nevada and very much so in rural Nevada. This, too, is a person with a master's level of education, and that master's must have required coursework in clinical mental health, so clinical mental illness piece. This person is qualified to treat individuals with substance use disorder and individuals with co-occurring disorder. So with one licensed professional, we're able to support an individual who has both of those disorders, which is a large percentage of our Nevadans in need. So here's the good news, thanks in large part to many of you who have served a long time. The stigma around mental illness is lessening. This is fantastic. My sister has lived heroically with bipolar disorder for 40 years, and she is a person who brought me into NAMI and into this work. But here's the bad news. It's great that we have many more licensed clinical social workers, for example. The bad news is we're losing ground in alcohol and drug counselors and LCADCs relative to the other three behavioral health professionals. So we have a shortage of professionals to deal with the very large amount of substance use disorder that we're experiencing, co-occurring disorder we're experiencing in Nevada. So here's my chart that you look across the licenses, and this shows 2014 on the bottom of the chart, 2020 on the top of the chart. 2014, LADCs were 19% of our behavioral health workforce. Now they're 10%. The good news is our gold standard there has gone, the LCADCs has had an increase, but we're talking about a single-digit increase. Still not enough. So what's a barrier that we can do something about here with SB 181? And where does this barrier come from? Really, it comes in my work with my clients. Their estimation is, and other looks show this to be the case. It's a point of historical origins. We're Nevada. We realized we needed to treat problem gambling a long time ago. We created a board of alcohol, drug, and problem gambling. People who were able to enter this field were able to enter with relatively little amounts of education, were able to get some supervision and an internship, and then were able to get licensure. That's in, let's call it our olden days. These other three behavioral health professions developed in more recent times, so they require a master's and 3,000 hours of supervised internship, whereas we have an historical statute, if you will, where LADCs and LCADCs now require the master's level of education, but still require 4,000 hours of supervised internship. And and that is, if you will, an equity issue with a lot of impacts. 1,000 hours more of supervised internship means 6 months more of foregone pay that you earn at an intern level rather than a licensed professional level. That's at least $9,000. So it's 1,000 more hours, it's foregone pay. Good news again, the greater recognition of mental illness and 1,000 hours faster to licensure has brought more attention to our behavioral health licenses, attracting more folks who are growing up in Nevada or other states who are this kind of caring individual willing to do this work. They're being attracted to behavioral health licensors. When we attract fewer interns, we have fewer supervisors available to support this work. It results in more folks who have SUD and co-occurring disorders who are untreated or waiting for treatment. And this, of course, results in very large individual, family, governmental, and societal costs to not be able to treat our Nevadans who need this specific kind of trained professional. So very quickly, SB 181 makes just a few changes. It takes looking first at licensed clinical alcohol and drug counselors, takes the 4,000 hours to 3,000 hours. It requires that 1,500 of those hours be with individuals with mental illness and substance use disorders. So the primacy of the mental illness, Nevada Psychiatric Association, for example, stepped forward and said they really wanted the majority of these hours to be working with individuals with mental illness because that is very complex. So 1,500 hours with mental illness and substance use disorder, at least 1,000 hours with individuals with alcohol and other substance use disorders, and then the remaining 500 hours could be either with either type of individuals, depending upon where you're doing your internship and what kind of clients they are primarily treating. That's our changes in Section 1 of the bill. In Section 2, We take the 4,000 hours for a licensed alcohol and drug counselor intern and take that to 3,000 hours with individuals with diagnosis of substance use disorder. Because so many folks do have co-occurring disorder, an LADC intern can earn supervision hours working with someone with co-occurring disorder, but they are only allowed to treat the SUD portion of that person's illness. So that's a safeguard there. We also increase the flexibility of who the supervisor of the LCADC intern is, because they're working with individuals on all pieces of the spectrum. We allow a behavioral health professional, one of these other behavioral health licenses, to supervise the mental illness portion of the LCADC's internship. And then there's one other fix. Fortunately, in statute, talking about licensure by endorsement and how do we move people forward expeditiously, there is an alternative track to licensure for LADC and LCADC. If you are already a licensed clinical social worker, marriage and family therapist, a clinical professional counselor, you may have, with just 6 months of appropriate supervision, you may add the LCADC or the LADC to your license. When someone did this positive change to statute, they left clinical professional counselor off of that alternative track. So we're adding CPCs. If you're already a CPC with 6 months more supervision, you can become an LCADC. So we think that was an oversight. So there you have it in summary. It's to update an historical statute to resolve an equity issue between substance use disorder treatment and behavioral health treatment, and to help us develop these critically needed professions. I am joined today in the Zoom room by Esther Quillisi of Vitality Unlimited, Lana Robards of New Frontier, and Agata Goransky, the Executive Director of the Board, to assist me in answering your questions. Thank you, Madam Chair. We are ready for questions from you and the committee.
Thank you for the presentation, Ms. Adler, and thank you, Senator, for bringing the bill forward. At this time, I will go to the committee to see if they have any questions. I'm going to start with Vice Chair Carlton.
Thank you very much. So I'm a little confused when I'm looking at the mock-up because it's showing under Section 1C, 2,000 hours to 3,000 hours. And you were talking about 4,000 hours and coming back to 3. So I'm not quite sure exactly how that all fits together. So we'll just need to clarify that since that 2,000 is out. I guess one of the concerns that I have is mandating the hours in mental health, because not all substance abuse is tied to mental health and not all mental health has substance abuse, but yet we are going to mandate that someone do 1,500 hours in something that they may not really be focusing on. They're focusing strictly on substance abuse, but yet in order to have that title, we're mandating the mental health side. So, I mean, all good mental health training is great. That's wonderful, but that doesn't necessarily cross over every single time. And I was just curious how you came to that amount of hours, because I think it's good to be familiar with it in case you encounter it with a patient, but not necessarily have it be dominant if you're focused on being a substance abuse counselor, not a mental health counselor.
Through you, Madam Chair, to you, Vice Chair Carlton, and I very much appreciate the question. When we drafted the bill originally, we originally had 1,000 mental illness and substance use disorder, 1,000 substance use disorder, and then 1,000, in either category so that it could be responsive to the clients where you're doing your internship. The Nevada Psychiatrist Association came to us and requested the change to 1,500 hours of those individuals who are co-occurring, because so many individuals do have co-occurring disorders, and I know this, from my own personal family history. What people will acknowledge is addiction. Alcohol, is common in our society. They will acknowledge addiction, but there really is an underlying mental illness. So very many of the people that we're treating really do have co-occurring disorders. But anyway, that is where the shift from 1,000 to 1,500 came from, was from a request by the Nevada Psychiatrists Association. It's not quite the right name, but.
So it wasn't the board that asked for it, it was the association that asked?
Yes.
Okay, that seems to be raising the bar a little bit on that one. And the second to last slide, if you could go back, please, if I may, Madam Chair. The second to last slide, the conversation about licensed clinical counselors. If you could go back through that again, because
Yeah.
I helped write some of these statutes, so I believe they were left, you said it might have been an oversight. I don't believe it was an oversight. I believe there was an evaluation of educational levels, and the line was drawn, and that particular profession ended up at a different level as far as education went. Now, if that educational level has changed, that would be something that we would want to discuss. So and which one did you say? I just want to make sure, because we went through it, and there are so many letters in that, I tell you. This committee is getting really good at acronyms, I'll tell you that, so.
Through you, Madam Chair, to Assemblywoman Carlton, I appreciate you raising this point. SB 37 from last session did quite a bit of work. As you know, CPCs and MFTs are licensed by the same board. And it did quite a bit of work on various qualifications of those two licenses, if you will, and bringing them somewhat more in tandem. So I would be glad to look back at SB 37 and consult with your committee on where we are with the licensure requirements for CPCs, to see whether, in fact.
And for the public certification, CPC is?
Clinical professional counselor, sorry.
Okay. So there's the clinical professional counselor, and then there's the licensed professional counselor. So there's a difference between the two, is that correct?
A clinical professional counselor is the term for a licensed clinical professional counselor. That is a licensed behavioral health professional.
Okay, and if I remember right, and I'm going back to Assemblywoman Leslie being in the building, Sheila Leslie being in the building when we did marriage and family therapist years and years ago, that's where a number of the cutoff lines were. So if those standards have changed, then I'd like to be aware of that, but there was a reason behind where cutoff lines happened, because we looked at education, and a number of different components, because you want to make sure, as in the medical field, you've got PA, RN, LPN, RN, APRN, it's a medical team. So we want everyone to practice at the top of their license, but we also know that everyone has a license for a different set of criteria. So thank you very much.
Thank you.
Members, any other questions? Okay, seeing none, we can move into testimony and support. Is there anyone in Carson City wishing to testify in support? Welcome, Ms. Foley.
Thank you, Madam Chair, members of the committee. My name is Helen Foley, and I am representing First Med Health and Wellness. I have to say that when Assemblywoman Carlton was in the Senate, in the Senate, I represented marriage and family therapists for about 25 years. And as each new profession came on that dealt with any kind of mental health issue, I hate to say this, but Senator Carlton was the queen of boards. And she helped create the boards and then combine the boards so that, like when problem gambling counselors came in line, they ended up going over with the alcohol and drug abuse counselors. There was a woman by the name of Dorothy North, and I'm sure that Senator Gogachia knew her well. She was quite a powerhouse around here. She ran some clinics in Elko, and they were drug and alcohol abuse clinics. She needed to legitimize that profession. She needed to raise those people up who had master's level degrees to that comparable level as other mental health professionals. But just because you have been working with alcoholics and were one in the past, that doesn't mean that you have that level of experience or education to become a mental health professional. So we did our best in those days to try to create these laws. Some have changed now. Many of them are deeply involved in mental health, and we need that. We have about 30 professionals, mental health professionals at First Med, and we see 1,200 patients every month. And it has only gotten stronger during, well, it started with 1 October, and then after this pandemic started, the need is tremendous. To have a skewed system where the alcohol and drug abuse counselors, the clinical alcohol and drug abuse counselors, are required 4,000 hours when everyone else in the mental health field only needs 3,000. This needs to be corrected so that we can incentivize people to have that dual type of licensure that the clinical alcohol and drug abuse counselors receive, because they can deal with mental health issues, co-occurring disorders, as well as the substance and alcohol abuse. So there may be some issues to tweak, to fine-tune here, but we strongly support this legislation so that we can grow the industry of mental health professionals. And we thank you so much for your time.
Thank you for your testimony. Is there anyone else in Carson City wishing to testify in support of Senate Bill 181? Okay, is there anyone on Zoom wishing to testify in support of Senate Bill 181? Okay, I believe we'll start with Miss, I can't see, is it Robards or is it Rollards? Is that a, Robards. Okay, Miss Robards, when you're ready.
Thank you, Madam Chair and members of this committee, for this opportunity to support SB 181. For the record, my name is Lana Robards, Executive Director representing New Frontier from Fallon. New Frontier has been providing services to Nevada, particularly rural Nevada, for 50 years this July. There are more Nevadans needing treatment. Their numbers far greater than we have seen before. Providers are getting harder to find, and yet we need more to provide the services that families need. Recruitment in rural Nevada has always been difficult, but getting harder with the lack of providers available. Alcohol and drug counseling has a long history in Nevada, beginning when there were people in the field without a high level of education. As these clinicians and their licensing evolved, so did the educational requirements for each level of certification or licensure. Behavioral health licensing, such as licensed clinical social workers, are more recent, so clinical supervision hours required were developed commensurate with their education and require 3,000 hours of clinical supervision. Licensed alcohol and drug counselors, LADCs, and licensed clinical alcohol and drug counselors, LCADCs, also require master's level education, and that, I believe, should be taken into consideration when this committee considers this bill. New Frontier also operates a 28-bed residential detox and treatment facility. These individuals generally present with debilitating addiction to alcohol and a wide range of drugs. Most suffer from co-occurring mental health and substance use disorders. Our focus at New Frontier has always been on the safety net clients, men and women, young and old, and those clients on Medicaid without income. They are in residential with us for 30 to 45 days, during which time they work with our alcohol and drug counselors and our mental health therapists. Aftercare treatment is essential, and since the majority of our clients come from all over the state of Nevada and eventually return home, they will need licensed counselors to work with in all of rural Nevada. New Frontier joined Vitality Unlimited as one of the first 3 providers in Nevada to become certified community behavioral health clinics, CCBHCs. As such, we provide a complete compendium of wraparound services to our co-occurring clients and their families. We need LADACs and LCADCs to carry out our mission of providing behavioral health services to all rural Nevadans. In support of this bill, we would respectfully appreciate the committee's consideration. I thank you for allowing me to be able to speak to you today. Thank you.
Thank you, Ms. Robards. And I believe we did have another caller on Zoom to testify in support. When you're on ready, just unmute yourself and state and spell your name for the record, and you can begin.
Good afternoon, Madam Chair and Committee. My name is Esther Quillisi. I'm the Chief Executive Officer and Chief Operations Officer for Vitality Unlimited. I want to thank Ms. Foley for mentioning Dorothy North. I remember sitting down with Dorothy and helping her write the model which increased, and the law which increased the backgrounds of the LADCs and the CADCs. So it was really interesting that Ms. Foley brought Dorothy up again. Dorothy passed away about 6 years ago. So I've been with Vitality Unlimited since 1984. I've been a licensed LADC for over 30 years. I also serve as a clinical supervisor for interns. Vitality's treatment centers are no longer just in Elko. We are located in various rural areas of Nevada and also in Las Vegas. Vitality Unlimited is a nonprofit, federally recognized 501c3 corporation with a long successful history of providing community services, affordable housing, high-quality substance use disorder treatment, and access to behavioral health services. We, too, were founded in 1971 and are celebrating our 50th year of operation. And I'd like to pause very briefly to say that the nonprofits in the state of Nevada, I think, had a birth from the public-private partnership which still exists today. You know, the Fed reached out and said, we'd like to establish local bases to support alcohol and drug treatment. And I remember seeing the original committee that signed the proclamation that they were part of the original group that did so. And Dorothy came in, but without state financing and assistance, we wouldn't be where we are today. And that public-private partnership still exists, thank goodness. I urge passage of SB 181 because the state needs this bill. We're finding it difficult to add to our workforce. We have an aging workforce, and we have a workforce that has slowly become disinterested in one of the most extreme issues facing Nevada, and that is the SUD problems. And we have a workforce that I think we need to combine and make sure that they have a background in substance disorder treatment. We need to support this mental health specialty in conjunction with the mental health specialists. This specialty has receded nationally because we're moving toward more mental health specialists who sometimes and many times don't want to treat people with addictions. They say refer to the specialists, the LADCs, the CADCs. Vitality Unlimited has tried to attract more clinicians by paying higher wages and improving the work environment. We have locations in Carson City, Elko, Dayton, Reno, Sun Valley, and an outreach office in Las Vegas. We think the provisions of this bill will be good for business for the state of Nevada. If we can help Nevada improve our state's record in behavioral health, we will raise the state's national profile. Vitality Unlimited and New Frontier provide integrated services, complete behavioral health. This is important because we address the whole person. We are both community behavioral health clinic model providers, and Vitality Center has 3, Elko, Carson City, and Dayton. We want to remove barriers for mental health professionals coming into the state. We also want equity across the professions, and this bill moves us towards this goal. I'm also concerned about pay equity for substance abuse counselors in relation to colleagues in the mental health treatment. Thank you for the opportunity to participate in the hearing today, and I welcome any questions.
Thank you, Ms. Quilici. We appreciate your testimony. Is there anyone else on Zoom wishing to testify in support? Okay, we will move to anyone in Carson City wishing to testify in support. Seeing no one here. Oh, we already did Carson City. Let's go ahead and move to the telephone line. Broadcasting, can we please check the telephone line?
To testify in support of Senate Bill 181, please press star 9 now to join the queue. Chair, there are no callers in support at this time.
Thank you. Is there anyone in Carson City wishing to testify in opposition? Okay, I don't have anyone signed up on Zoom, so broadcasting, can we please check the telephone line?
To testify in opposition on Senate Bill 181, please press star 9 now to take your place in the queue. Chair, there are no callers in opposition at this time.
Thank you, BPS. Is there anyone in Carson City wishing to testify in a neutral position to Senate Bill 181? Okay, I don't have anyone signed up to testify on Zoom, so broadcasting, can we please check the telephone line?
Testify in neutral on Senate Bill 181, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 880, please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Agatha Gorowski, Executive Director for the Board of Examiners for Alcohol, Drug, and Gambling Counselors. I'd like to testify as neutral. Only I can't support the bill officially because it wasn't discussed with my board. However, I think it's very important that we are going to limit the hours for alcohol, drug, and gambling counselors and licensed clinical alcohol and drug gambling counselors to level the standards with other mental health providers. I definitely think that 4,000 hours is an overkill at this point, especially if we have master's level professionals providing those services. Thank you.
Thank you. Since we do have someone from the board on the line, members, do you have any questions? Okay, thank you, Ms. Lawridge. Broadcasting, next caller, please.
If you recently joined the call and would like to testify on neutral on Senate Bill 181, please press star 9 now to join the queue. Chair, there are no more callers in neutral at this time.
Thank you so much, Broadcasting. And Senator Gocochea, would you like to give any closing remarks?
Thank you, Madam Chair, members of the committee. I'll get out of your hair. I do really appreciate your consideration of the bill. I want to thank Esther and Lana for the work they do in rural Nevada with their services. Thank you all, and we'll work with you. Hopefully we can get it passed. Thank you.
Thank you, Senator. And with that, I will close the hearing on Senate Bill 181. Members, we have our last bill on the agenda. I see that Senator Sievers-Gansert has joined us, so I will open the hearing on Senate Bill 217, which revises provisions related to applied behavior analysis. Welcome, Senator. Welcome back.
Yes, thank you, Madam Chair and members of the committee. I'm happy to be here for the second time this week. Today, I'm here to present Senate Bill 217. I'm joined by Molly Halligan, who you can see up in the corner there. She's the chair of the Public Policy Committee for the Nevada Association for Behavior Analysis, and Dr. Bridget Fronefel, assistant research professor at the Nevada Center for Excellence in Disabilities and the current president of the Nevada State Board of Applied Behavior Analysis. So in 2009, Nevada passed Assembly Bill 162 that established health insurance funding for the treatment of autism spectrum disorders using applied behavior analysis. The licensure for these professionals was placed under the Board of Psychological Examiners at the time. If you fast forward to 2017, I was asked by the applied behavior analysis community to bring forward legislation to create a board specifically for behavior analysts. That was SB 286. The Board of Psychological Examiners already had a heavy workload, and so the processing of licensure for behavior analysts was slow. At that time, in 2017, we only had 40 registered behavior technicians, RBTs, licensed in the state. And RBTs are the individuals who work, hand in hand with the children who are affected by autism. With this new board, we were hoping to significantly increase the numbers of RBTs and also other providers who provide behavior analysis. And when it was created, this new board needed some time to get up and running, so it was initially staffed by Aging and Disability Services under the Department of Health and Human Services. So Aging and Disability Services has provided the staffing to this new board since 2017. Today, we have over 1,200 RBTs, and again, we were at 40 in 2017. We have 326 licensed behavior analysts and 26 licensed assistant behavior analysts in the state. So moving this board, or creating this board and moving it out of the Board of Psychological Examiners really worked well. The bill before you today, SB 217, transfers the responsibilities concerning the licensure and regulation of the practice of behavior analysis from Aging and Disabilities to the Board of Applied Behavior Analysis. As mentioned earlier, ADSD has been providing support and staffing since it was formed, and now the board is ready to operate independently. Because of the length of the bill, I asked LCB to create a summary table that tells you what the different components are. So you have this in your exhibits if you're able to look at those. So what I thought I would do, instead of going through page by page the bill, I know you've had quite a few bills today, is just to highlight some of the major components and then open it up for questions. So if you were to look at sections 12 through 18, what that does is it adds behavior analysts, assistant behavior analysts, and RBTs to the definition of provider of health care in NRS, and subjects them to the same requirements as those professionals regulated by the boards. So that's a big piece when we move them over to providers of health care. Section 53 modifies the board's membership to allow a behavior analyst to join the board. So there's different levels of analysts, and so it opens up a slot for that professional. Section 58.3 is about background checks, and I know you were talking about those earlier. And in 2017, we of course required background checks for the various providers. But in 2019, we tried to streamline it because what was happening is there's a national board that licensed them, and then also the state licenses them. And so we tried to allow them to have one background check. But when that information went to the FBI, they rejected it. They like a background check for each entity and for each licensure. So this language reverts back to the original language that we had so that they're required to get the background checks. And again, they always got the background checks, but it was sort of how they were getting them and whether they were going to need to get two, one for the professional board, that's a national board, and one for the state board. So that's what that does. Sections 97 and 101 include the dates of transfer of funds and the substantive provisions. And we also, early today, submitted a conceptual amendment Originally, we were looking to October 1st to transfer all the responsibilities to the board, but the board, and we have 2 representatives, feel like they're ready now to be able to take on those responsibilities. So we do have a conceptual amendment that just changes the date to July 1 that we would appreciate your consideration. So now I'd like to open it up for questions either to me or to our representatives who I introduced you to at the very beginning. Thank you.
Thank you, Senator Ganser. I do have a couple questions, but I'm going to let members go first. So, members, do you have any questions for our presenter? Okay, I'm going to go ahead and ask. Now, as I was reading Senator Ganser through the bill, and again, just a lot of times I have questions just to help me understand the bill. And I know we're deleting the, well, let me give you a section. Well, it's in a few sections, but we're deleting the definition that's in this bill of a licensed assistant behavior analysis and then referencing NRS 437.005. And I noticed that the definitions are slightly different. So does this mean that there was 2 different versions of this definition in statute, and we're just going to reference now 437.005?
So for the record, Senator Heidi Sievers-Ganser, I don't know if I said that at the beginning, so you know, I'd have to look up those specific examples. At the very beginning, when we created the new board, we also were creating a separate licensure, like a Nevada licensure. But in the end, we didn't need that because the national organization was able to register folks. And again, we were trying to increase the number. And so I'm not sure if Molly or Bridget could answer that particular question, but there was a time when we had sort of a Nevada-based licensure, which didn't really pan out. So we went to the national certifications.
Yeah, and I mean, I guess the definitions, they are different. Like the one that we're deleting is a licensed assistant behavior analyst, and now we're referencing assistant behavior analyst.
I think we have an answer up there. Yeah.
Yes.
For the record, Molly Halligan, good afternoon, Chair, Madam Chair and the committee. Thank you for letting us present today. So 437.050 actually refers to the registered behavior technician, I believe.
Oh, and I believe the reference is NRS 437.005.
Oh, 005. There shouldn't be any change to the license, the assistant behavior analyst. We had wanted to include the language licensed at one point, but for various reasons, we chose to leave that word out, licensed.
Okay, thank you. And just another question. I know that now we're requiring the board to create an orientation program for any board members who are going to be joining the board, and they have to be completed within 60 days. So is it going to be, I don't see it in here, so, and I'm assuming it is, but I just want to make the record clear. It's going to be the responsibility of the board to create that orientation. It's in section 47, page 48. It's going to be the responsibility of the board to create that training, what that training looks like.
Thank you. I'll let Molly or Dr. Fronnefeld answer that question. So yes.
For the record, Molly Halligan again. And yes, the intention is that the board will create that training just to ensure that all valid manuals and laws and regulations have been, adhered to by the new incoming members.
Thank you, Ms. Halligan, and I think that just answered my second question to that. Ms. Halligan, so you guys won't require any existing members, it'll just be new members who would be required to go through the orientation?
That was the intent, yes.
Okay, thank you. And members, any questions? I'm going to go to Vice Chair Carlton so I don't suck the room.
Thank you. So as you looking to transfer this out of aging and disabilities, and because they were providing the support staff, that would probably have made it a little more affordable for them to get going. And I do remember the conversation in 17, because there were very few of them. We didn't think that they could substantiate their own board, and they might end up biting off more than they could actually handle. So having it in aging and disabilities worked very well just to get them up and get them running. But now as you're moving this from there to a fully fledged board, how are the fees going to be dealt with? And as far as their budget goes, will they be able to capture enough licensing fees that they should be able to stay self-supporting as we move forward? Because we've got a couple that are barely making it now, and we just want to make sure that we give them all the tools they need to succeed.
Thank you, Vice Chair Carlton. For the record, Senator Heidi Sievers-Ganser. The behavior analysts have been very thoughtful about this, so I'm going to let them answer, but they have waited 4 years to look towards this transfer. And what I mentioned earlier is, some of the numbers, we've gone from 40 RBTs to over 1,200, and we've got 230-something analysts and so forth. So I'll go ahead and let them answer the fiscal questions, but the numbers have increased significantly, and that's such a valid question because sometimes there aren't enough folks in an industry to support a board.
Dr. Fernapfel, for the record, thank you for the question, Assemblywoman Carlton. In answer, we have spent 4 years analyzing the data and the numbers in relation to our fees and the budget and comparing ourselves not only statewide, but also nationally to other boards of similar makeup with similar numbers, with similar fee schedules. And the data indicates that we will be able to sustain independently from this point on.
And if I may, Madam Chair, so is your fee schedule in statute?
Thank you for the question. Dr. Knopfel, for the record again. It is in our corresponding NAC, not in NRS.
Okay. And thank you, Madam Chair. And typically, and when I was reading the opening statements on this, to have this board operate as other boards do, we typically put the fees in statute. That way we know what the guidance is, and we typically list the top end so that if you need to work up, you can work up to it. That just gives a level of comfort to licensees to know that any fee changes that would have to happen would have to come back to the legislature and couldn't just be changed, and I don't want to say arbitrarily, but changed without review, because we would not be reviewing those regulations. They would be in your administrative code. So is there an intent to put the fees in statute?
Madam, thank you, Madam Chair, through you to Assemblywoman Carlton. For the record, Senator Heidi Severs-Gansert. The original bill, I believe, had the license fees in it, and we may have had a cap up to, and we can actually do a little bit of research in there because I know it wasn't an open door. We, as you know, we rarely, and probably never, just leave it totally uncapped. I think we probably had a structure. I just don't remember because it's been a couple of years, and because they're not changing anything, it's not in this legislation. They're not proposing to change for whatever the fee scheme is right now.
And I guess what I need, and I don't remember, and I apologize, but are the fees in statute somewhere? Because if they are and they're not changing, that's one thing. But if they're not in statute and you're going to a fully fledged board, if we're going to operate like all the other boards in the state, then those fees should be in statute. And it wouldn't be changing the fees, it would just be making sure that they're noticed inside of the statute. And we can research that further.
Thank you. For the record, Senator Heidi Severs-Gansert, I think we just need to research it because I don't think it's completely open, and I think they set them through code, but I'm pretty sure that we have maximums. And right now, the intent is not to raise the fees, but I understand because they're going on their own. We've had such a vast multiple of how they started or where they started as far as the numbers. I think that's part of the reason they feel comfortable going out on their own, and they've been very thoughtful about analyzing the data to make sure that they can afford to do it. Thank you.
Thank you.
Okay, and Senator Severs-Gansert, I have just one more question before we go to testimony. On page 49, section 48, where it gives the definition of practice of applied behavior analysis and what it means, under sub 2, it says this term does not include diagnosis, psychological testing, psychotherapy, cognitive therapy, psychoanalysis, or counseling. Can you just explain that section a little bit to me? I'm a little bit confused about why these wouldn't be included in especially the counseling one, since that seems what the.
Thank you for the record, Senator Heidi Severs-Gansert. I'm going to let them answer, and they're not counselors. This is a lot of hands-on work with children, but if you wouldn't mind either Molly or Bridget answering.
Thank you.
Molly Halligan, for the record. We do not fall under the category of counselors. We fall exclusively under the category of behavior analysts. As Senator Severs-Gansert has said, that we primarily work with children with autism. We do work with other populations, but we do not provide counseling services.
Or diagnosing patients either?
No, we do not. No,
Okay.
that is not within our scope.
Oh, thank you. I appreciate that. Okay. Members, any other questions? Okay, then at this time, we can go ahead and move into the testimony portion of the bill hearing. Is there anyone here wishing to testify in support? Okay, seeing no one here in Carson City, and we've already had our presenters on Zoom, we can go ahead and ask broadcasting to check the telephone lines for anyone wishing to testify in support of Senate Bill 217.
To testify in support on Senate Bill 217, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 120, please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Good afternoon, Madam Chair, members of the committee. Stephen Cohen for the record. Stephen with a V, Cohen as in the Assemblywoman. I'll keep it nice and short and sweet with less than a month to go. Ditto. With that, Madam Chair, thank you, and I yield.
Thank you for your testimony, Mr. Cohen. Broadcasting, next caller.
Caller with the last 3 digits of 823, please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Hi, my name is Dr. Carrie Milico, KERRIMILYKO. I'm a board certified behavior analyst at the doctoral level, and I'm a licensed behavior analyst. I'm a former chair of the Nevada State Board of Applied Behavior Analysis, and I'm the co-owner of the Learning Consultants, a behavioral health agency in Reno, Nevada. And I would just like to testify on supporting this as it brings protection to our consumers and allows provisions for the advancement of our of the board. Thank you so much.
Thank you for your testimony. Broadcasting, next caller.
Chair, there are no more callers in support at this time.
Thank you. Broadcasting. Seeing no one here in Carson City, no one signed up to testify on Zoom in opposition. Can we check the telephone line, please?
Testify in opposition on Senate Bill 217, please press star 9 now to take your place in the queue. Chair, there are no callers in opposition at this time.
Thank you. And seeing no one here to testify in neutral and no one signed up on Zoom, can we please check the telephone line?
To testify in neutral on Senate Bill 217, please press star 9 now to take your place in the queue. Chair, there are no callers in the neutral position at this time.
Thank you. And Senator Sievers-Gansert, we do have another question for you before we go to your closing remarks. I'm going to go to Assemblymember Considine.
Thank you, Madam Chair, for letting me ask this question. I don't know if this is typical practice or not, but on the memo refers to Section 25 and says that Section 25 will allow the board to grant a license to a limited liability company. Is that typical of boards to grant licenses to LLCs? And how does that work in this situation?
Thank you for the record, Senator Heidi Sievers-Gansert. I'm going to let one of our representatives answer that question because there may be individuals who are set up as an LLC. I'm not quite sure.
And we can always ask our legal to chime in too,
there you go. Thank you.
if he knows with respects to other boards.
Molly Halligan again for the record. I believe that is related to the definition of healthcare provider. So that was part of that language. So I think we would have to defer to LCB on that.
I'm going to go to our legal counsel, Mr. Quast.
Thank you, Madam Chair. Sam Quast, Committee Counsel. Since Section 25, excuse me, since this bill is moving Chapter 437, the board created under Chapter 437 to the sort of independent board regulated by Title 54. What Section 25 is doing is aligning these provisions that allow for the licensure for a limited liability company, just like any other board under Title 54, 55, or 56. So that just makes it consistent with all the other boards.
Thank you. And Assemblymember Constantine was, okay, thank you. Okay, Senator Severs-Ganser, would you like to give any closing remarks?
Thank you, Madam Chair. For the record, Senator Heidi Severs-Ganser. So I took a moment to look up the fees, and the fees are prescribed by regulation. The board shall prescribe by regulation fees for the issuance, renewal, and reinstatement of a license or registration and any other services provided by the division. The board shall ensure, to the extent practicable, that the amount of the fees is sufficient to pay the costs incurred by the board and the division under the provisions of this chapter without limitation, compensation to the board, and does not exceed the amount necessary to pay those costs. So they're supposed to align with the costs of the board. And because the membership or the licensure has increased greatly, they're confident that they can cover the costs. And so we've not proposed to increase those fees, but you're right, they are in code and they're not in statute. And I'd appreciate your support on this bill. Again, this board has been in place for 4 years now, and we're extremely grateful to Aging and Disability Services for helping them start out. But they're extremely well organized and brought this to me this time, and did wait for not 2 years, but 4 years to be able to go out on their own. So I appreciate your consideration.
Thank you. With that, I will close the hearing on Senate Bill 217. Okay, members, we have reached the last item on our agenda, which is public comment. While we give those listening over the internet time to call in, because we do have a 1-minute delay, I will go ahead and read through our public comment housekeeping and remind everyone that public comment is a time to talk about matters that fall within the jurisdiction of the Commerce and Labor Committee. If you direct your remarks to issues over which this committee has no oversight, I will ask you to redirect your remarks or terminate them. The public has already been given time to support or oppose specific legislation, and we open and close the hearings on bills so that we can establish a public record of the testimony. Therefore, public comment is not intended to be a continuation of a bill hearing. We do limit public comment to 30 minutes and 2 minutes per caller. I would remind everyone to be respectful to committee members and other witnesses, and do not comment on testimony provided by other speakers or make personal attacks. You may always submit your remarks in writing to the committee secretary for inclusion in the record. With that broadcasting, is there anyone in Carson City who wishes to testify, who wishes to make a public comment? Broadcasting, could we
take your place in, I apologize, Chair. To take your place in public comment, please press star 9 now to join the queue. Chair, the public line is open and working, but there are no callers at this time.
Thank you, broadcasting. Members, before we adjourn, any comments from the committee members? Okay, seeing none, thank you all for your attention to all of the bills. We will be meeting this Friday. You should have received the agenda. Just remember to please note the start time, and we are adjourned. Thank you, everyone.